Introduction. Every civil suit shall be instituted by presenting a plaint to the court or such officers as it appoints. In that behalf, plaint is the written document which is presented to the court for instituting a suit. Order 7. Rule 1 to 18 deal with the various provision relating to the plaint. Meaning, there is no statutory definition given for plaint in CPC. A plaint is a legal document that contains the claim made by the plaintiff when they bring a case to a civil court. It is the first step in starting a lawsuit. Through the help of the plaint, the plaintiff narrate or describe the cause of action and relate information which is considered as essential from the viewpoint of the suit. Section 26 of CPC state that every suit shall be instituted by the presentation of a plaint or in such other manner as may be prescribed. Provision of plaint in CPC. Order 7 of Civil Procedure Code deal with the provision of CPC with different rule that covers various aspects of what should be a plaint. Rule 1 to 8. These rules explain what specific details should be included in the plaint. Rule 9. These rules tell how the court should admit the plaint. Rule 10 to 10b. These rules discuss what happens if the plaint in CPC need to be returned and how parties should appear. 11 to Rule 11 to 13 weigh out the situation in which plaint can be rejected by the court. Essential requisite or particulars or content of a plaint. The content necessary for the plaint are mentioned in Rule 1 to 8 of Order 7 of CPC. These are mentioned below. Title. The plaint shall contain the name of the court in which suit is brought. Example, the High Court of Karnataka at Bengaluru. Case number. Plaint should contain a case number to be allotted by the office of the respective court. Particular regarding plaintiff. The plaint should contain name, descript on and residential details of the plaintiff. If there are more than one plaintiff, then each plaintiff name, description and residential details shall be mentioned in the plaint. Name and particular of defendant. The name, description and place of residential of the defendant, if more than one defendant should be mentioned. Minor or person of unsound mind. Where the plaintiff is a minor and unsound mind, the statement to that effect must be made. Corporation or firm. When the suit is by a corporation or a firm consisting of more than one person, the name, description and place of business of the corporation of firm who is suing need to be given. Framing of plaint. The plaint is the first document which is presented to the court on which the claim of the plaintiff depends. As such, framing a plaint is very sensitive and important functions of a pleader. Body of a plaint. The plaint should contain in its body the fact constituting the cause of action and when it arose. The facts are given in numbered paragraph. Jurisdiction. The fact showing that the court has jurisdiction. Relief. The relief which the plaintiff claim through the plaint. Where the plaintiff has allowed a set of or realm quashing a portion of his claim. the amount so allowed or relinquished, relinquished, and a statement of a value of subject matter of the suit for the purpose of jurisdiction and court fees so far as the court admits. Rejection of a plaint. Rejection of a plaint can be exercised at any stage of the proceeding under Order 7, Rule 11, even without a written statement. Rule 2, Order 7 lays down the case in which the plaint shall be rejected as mentioned below. Non-disclosure of the cause of action. If the cause of action is not clearly mentioned in the plaint, making it impossible to prove the harm suffered by the plaintiff, the court may reject the plaint. Case law. The SNP Shipping Service Private Limited versus World Tankers. The plaint was rejected and suit was dismissed under the Order 7, Rule 11 of CPC, Rule 11 bar A of the CPC. B. Under valuation of relief. If the relief bought by the plaintiff is undervalued and the court asks plaintiff to correct the valuation within a given time frame, but the plaintiff failed to do so, the plaint in CPC may be rejected. See, improperly stamped documents. When all the documents are not properly stamped and the court require the plaintiff to provide the required stamp paper within the specified time period, failure to do so by plaintiff may lead to the rejection of the plaint. Lack of legal basis, where the suit appear from the statement in the plaint to be barred by law. Failure to submit duplicate copy. If the plaintiff failed to submit a duplicate copy, the court may dismiss the plaint. Non-compliance with the rule of Order 7, where the plaintiff failed to comply with the provision of Rule 9, then the court may reject the plaint. Case law. Akhtar Hussain Muhammad versus Suresh Singh. The plaint was rejected on the ground that the suit was barred by limitation. Remi Sethi Venkatanna versus Nasian Jamal, 2023 Supreme Court. In this case, the plaint was clearly barred by limitation and there was plaint out to have been rejected under Order 7, Rule 11D of CPC. Conclusion. It can be concluded that plaint is a legal document that initiate a civil lawsuit. It provide a clear and structured account of the case, including the parties involved, the fact leading to the cause of action, the relief sought, and jurisdictional details.